Good morning, everyone, and very sorry for the delay, which is due to technical issues. My name is Olivier Andre. I am Client Relationship Advisor with Freshfields International Arbitration Group in New York, and also the chair of the campaign for Greener Arbitration's North America Committee. Prior to joining Freshfields last year, I was Senior Vice President at the International Institute for Conflict Prevention and Resolution in New York. I'd like to thank Francois and the BVI International Arbitration Center for the invitation to participate in this fourth edition of BVI Arbitration Week, and for all of you for attending our panel this morning. Frankly, I'd rather be with you rather than this in ugly office in the BVI. I saw that the weather is gorgeous this morning, so very sorry not to be with you today. It is my pleasure to moderate this panel on arbitration and climate change with a group of experts, many of whom are currently in Glasgow, participating in the COP26, which will give us an opportunity to get real-time updates on what's happening at this very moment in Glasgow. I will introduce them in a minute. So through the Kyoto Protocol and Paris Agreement, countries have agreed to reduce greenhouse gas emissions to keep global warming below the aspirational goal of 1.5 degrees Celsius this century. But as we've heard in the news, we are already at 1.2 degrees Celsius. And according to the latest emissions gas report, the world is on track for a global temperature rise of 2.7 degrees Celsius by the end of the century, despite new national climate pledges combined with other mitigation measures recently adopted by various countries. In fact, carbon emissions, which had drastically been reduced last year due to the pandemic, apparently are back with a vengeance. To stay on track, the world needs to reduce by 50% its annual greenhouse gas emissions by 2030. So as the UN Secretary General Antonio Guterres puts it, the report sounds code red for humanity, and at this point, every fraction of a degree counts. That is why this year's climate change conference in Glasgow is so important. In today's panel, we will discuss the latest on COP26, of course, the role of arbitration to resolve state-to-state disputes under the UN climate regime, the use of arbitration in commercial and investor-state arbitration, and finally, the role the arbitration community can play to resolve climate change-related disputes and to conduct greener arbitrations. We will reserve a few minutes at the end to answer questions, but I'm not sure we will have time because we started a little bit late and our speakers need to leave. Stephen, I know, needs to leave at 10, so we might not have time. So let me introduce the speakers. First, Dr. Stephen Minas. He is an associate professor at the Peking University School of Transnational Law, chair of the UNFCCC Technology Executive Committee, member of the advisory board of the Climate Technology Center and Network, and senior research fellow at the Transnational Law Institute of King's College, London. Stephen is a member of the EU negotiations team in the United Nations Framework Convention on Climate Change, that's the UNFCCC, and has worked on climate law and governance in various capacities. Stephen is also a member of the Chartered Institute of Arbitrators. We are missing a speaker, Wendy Miles, who is also in Glasgow and which is probably held up in some of the discussions there. We'll see if she joins us. We have our second speaker this morning, who is Professor Dr. Diane Desierto, who is a professor of law and global affairs, LLM faculty director at Notre Dame Law School, with a joint appointment as full professor at the Keough School of Global Affairs at the University of Notre Dame. She holds a concurrent appointment as professor of international law and human rights at the Philippines Judicial Academy of the Supreme Court of the Philippines. Professor Desierto is academic council member of the Institute of Transnational Arbitration, editorial board member at the European Journal of International Law, Journal of World Investment and Trade, and International Law Studies, and was one of the drafters of the 2019 Hague Rules on Business and Human Rights Arbitration. She is the chair rapporteur of the United Nations Expert Group on the Right to Development. Diane will bring to the discussion the very interesting perspective of the Alliance of Small Island States, AOSIS, the 43 states that comprise the world's smallest islands and low-lying coastal areas. Welcome to everyone.
Wendy.
So we'll get, and I have, of course, François Lassalle, who has joined us here. And François, would you like to introduce yourself briefly for the very few who don't know you?
I'm the CEO of the BVI International Arbitration Center. I was supposed to jump in at the very end, but given that we struggled to connect with Wendy this morning, I thought I would jump in at the very beginning. I can see that Wendy is joining in right now. So I'm going to ask the production team to take me out of the picture so that you can enjoy the rest of this webinar until you call on me later on.
Thank you, François, and we will call on you later on. So we will introduce Wendy, who will be Wendy Miles, who will be joining us momentarily. Wendy has practiced as counsel and arbitrator in international commercial investor state arbitration for the past 25 years, with a focus in energy, natural resources, and infrastructure sectors. She is currently on the panel of arbitrators and conciliators at ICSID. Since 2014, she has taken a particular interest, in part prompted by her sons, in climate change, and decided to try to help figure out what can and should be done in response to it from within the system she knows best. So while we're waiting for Wendy, we'll jump right in the discussion. The 26th Conference of the Parties, COP26, the latest iteration of the UN's annual climate change conference, started on November 1st. We've heard a lot in the news about it, and will continue until November 12th. What is at stake at COP26? Is the conference on track to be a success? Can 200 countries with widely different interests agree on anything? I'll start posing this question to Stephen, who is live from Glasgow.
Indeed, I am, Olivier. And if the weather is a paradise in BVI, it's certainly not in Glasgow, but it's nevertheless a pleasure to join you. Can I begin by thanking Francois and the BVI International Arbitration Center for this invitation, but more importantly for having this event. I think this topic could not be more timely, and it's a credit to the center to be in this space. So indeed, we are in Glasgow. I'm literally just popped out of the negotiations, and there is a lot at stake at this COP. First of all, what is not at stake? There is no new treaty to be agreed here. This isn't Paris, it's not Kyoto, but there are some very important decisions to be made to operationalize, to implement the Paris Agreement. So this notably includes the rules for the market mechanisms, which are established in Article 6 of the Paris Agreement. It also includes very important rules on transparency, so that we can be confident that declared climate actions are actually being implemented to a certain standard. And of course, a very important discussion on finance. There is evident dissatisfaction with the falling short of the $100 billion per annum goal, but there is also the work to start the negotiation for a post-2025 quantified goal. So this is all negotiation. And then beyond that, you have very important announcements of coalitions, agreements, pledges. All of that is beyond public international law, but I would suggest it's often the main game. The real economy changing, and these COPs are part of that process as well. Thank you. Looking forward to hearing from colleagues also.
Diane, we'll turn directly to you. In your view, what is at stake at COP26? What are the main discussion points? What can and cannot be achieved at this conference?
So thank you, Olivier. My role here is actually to articulate a position that has been repeated, but often has been neglected. And that is the position that's taken by the Alliance of Small Island States. At the beginning of COP26, ALSIS actually called for direct attention to loss and damage as a distinct issue in its own right, not just on the fringes of mitigation and adaptation issues. The particular issue regarding the almost negligible contribution of small island developing states to carbon dioxide emissions and climate change, which is less than 1% of global emissions, and yet it is small island developing states that are facing the highest cost and the highest price from the continued subsidy of well over $3 trillion in support of the fossil fuel industry. Part of the clamor of the small island developing states includes the lack of redress, in particular for loss and damage. And as we saw from the statements by the Prime Minister of Antigua and Tuvalu at the start of this conference, that they are setting up a commission, particularly for the submission of possible claims involving climate change and international law, potentially to the International Tribunal on the Law of the Sea. But as they also said at COP26, that even if no formal mechanism for loss and damage compensation has been established, they are prepared to seek justice in appropriate international bodies. So the stakes are high. They have already, particularly small island developing states, have already tried avenues at the International Court of Justice, have also sought refuge at the Human Rights Committee of the United Nations. They have not obtained any access to the promised $100 billion climate financing. And we're looking here at the urgency of scenarios where Kiribati has already declared that there are climate change refugees as a result of sea level rise. The latest report coming out of the World Bank acknowledges that the sea level rise faced by small island developing states will require intensified, expedited investment, particularly not just for mitigation mechanisms for small island developing states, especially in the Pacific Atoll region, but also, more importantly, for adaptation, given the fact that sea level rises are occurring in a much greater scale and faster frequency than was expected or targeted under the current situation. So I'll leave it at that for now.
Thank you, Diane. So let's drill a little bit into what is of interest to us, which is arbitration and the link with climate change. And let's start by discussing the role of arbitration, the role that arbitration currently has under the UN climate regime. And if you could explain that to us, let's start with Stephen. What role does arbitration currently have under the UN climate regime? Is anything under negotiation at the moment at COP26?
Certainly. Well, certainly there are no specific negotiations in arbitration. It's perhaps a little known fact that the Climate Convention actually calls for the establishment of a dispute resolution mechanism under the law and sets out arbitration as an avenue for that, and calls for the adoption of protocol and annex. I don't remember the language, but in fact, nothing has ever done and nothing has ever taken place. It's essentially a dead letter. The reason for that, as far as I can gather, is that parties prefer to resolve their climate differences, if at all, in the diplomatic process. And what we've really seen here is 30 years of diplomacy, some hard law, but mostly what we would know as soft law. The Paris Agreement simply replicates that status quo. So we don't expect binding arbitration as between states under the Climate Convention or the Paris Agreement within the period during which we have to deal with the climate crisis. But there is, in fact, a very important practical role for arbitration directly under the various climate treaties. And this is in terms of solving commercial disputes in the securities that are established under the market mechanisms of the Kyoto Protocol. And it's perhaps well known that there is a clean development mechanism under the Kyoto Protocol, which has been a very significant generator of investment in climate action projects, renewable energy, etc. It's generated carbon credits, and typically the contracts in respect of the dealing with those credits are subject to international commercial arbitration. Now, the negotiation here in Glasgow is not about arbitration, but it is about the setting up of a new market mechanism under Article 6.4 of the Paris Agreement, and also for the establishment of rules to guide voluntary transfer of mitigation outcomes bilaterally between states. So a different, but also potentially a form of market mechanism. And I would foresee that arbitration will have an important role to play in resolving disputes at that level, consistent with the experience under the Kyoto Protocol. Thank you.
Okay, so you've just explained, if I try to paraphrase a little bit, the emission trading mechanisms that are provided for under Article 6 of the Paris Agreement, right? And the disputes that could arise out of these market mechanisms. If I understand you correctly, what is being negotiated is the details of these mechanisms at the moment, but we don't know yet any specifics about how arbitration will be used in order to resolve the disputes under these mechanisms, right?
Correct, and nor would we expect those details to emerge from this conference. Those details will find their way into template contracts, such as those of the International Emissions Trading Association, those which are used by sovereign governments in their dealings in carbon crediting and various similar projects. So it's really at the level of the contracts themselves that you would expect arbitration to emerge as a preferred dispute settlement option, not here from the Conference of the Parties.
Okay, and the Paris Agreement introduces new sustainable finance norms. What are these norms, and how can arbitration help to mainstream and enforce them?
The Paris Agreement, in my view, has made a very important contribution to climate law in its three goals. So in Article 2.1 of the Paris Agreement, there is a mitigation goal, the famous 2 degrees but better 1.5 degrees. There is an adaptation goal, but there is also something new, which is Article 2.1c, which is setting the goal of making all finance flows consistent with climate mitigation and adaptation. So what does this mean? This is broader, far broader than the very important finance which is provided from developed to developing countries. And clearly that work has to be continued and scaled up. And that's dealt with by Article 9 of the Paris Agreement. But this finance flows goal is talking about making, in a sense, all finance climate finance, because it is not finance that perpetuates the climate problem. So it is addressed to national legislation, such as we've seen in the EU with the development of the taxonomy regulation, but also to transnational financial standards coming out of the private markets themselves. And we've seen a lot of work, a lot of announcements in the market domain here in Glasgow, frankly, a lot of criticism of those announcements as well. We have to be careful of greenwashing, but there is this very important goal in the Paris Agreement to transform finance overall. And that's clearly relevant to dispute resolution, of course, because in the markets, where there are markets, there are disputes, and arbitration has a role to play.
Great. Wendy, have you joined us? I can't tell. I see your name, but I do not see your face.
I am here. I see my face. Does anybody else?
I can see Wendy, just to clarify.
You may have to press
right.
2 on your arrows.
Oh, that's right. I see.
All right.
Yes, okay.
No,
I see you now.
I've been here a little while, Olivier. Hello, everybody. I'm sitting outside on the stone steps in a very cold Glasgow, so I wish I were with you, Francois.
We all do. That it's a beautiful weather in British Virgin Island today. So, all right. So I wanted to. I know you don't have a lot of time, Wendy, because you need to leave and go to another meeting. So we might have to jump a little bit in the discussion here. So COP26 involves state-to-state negotiation under the UNFCCC and Paris Agreement are public international law instruments. To what extent is commercial law obligations and therefore arbitration involving non-state parties even relevant, Wendy?
Yeah, so let me, I hope you can hear me okay, the wind is blowing. Just let me pick up on two things that Stephen and Diane both said. First of all, what Stephen said is the Article 24 dispute resolution agreement in the Paris Agreement is an opt-in for ICJ litigation or PCA arbitration. 3 states have in Tuvalu, the Solomon Islands, and the Netherlands. And we worked very hard with the IBA and other legal stakeholders in Bonn in particular to try and get more states to sign up. And the reason they gave us for not signing up, and we particularly with the Netherlands delegation pressed on the Association of Small Island States, the answer was, if you've just gotten married, you don't want to be negotiating the prenup. And so 2 years in from Paris, the enthusiasm, the relief about getting 1.5 in the Paris Agreement was so palpable that nobody dared mess with it. That might have changed because Tuvalu and Barbuda and Antigua have brought this claim now. So the litigation's on. So I'd be very interested to know if that attitude is going to change. But meanwhile, there is mandatory.
I think you're breaking up, Wendy, unless it's coming from my side.
So also, I don't know.
Sorry, we just lost you for a moment.
Okay, I was just making the point that Article 24 in the Paris Agreement has mandatory conciliation. So there is mandatory dispute resolution for all parties. Can you hear me?
Yes.
Yeah, so the decision isn't binding, but the process is mandatory. So I think that's important and hasn't been utilized yet. As for the private sector, coming to the question you asked me, the real action is not happening at this COP in the negotiating room. The real action is happening out in the pavilions. It's happening with the private sector conversations and with the public-private partnership conversations. And it's trying also to integrate the Indigenous people's voice as well, which falls between the gaps in both. And the biggest takeaway from this COP, the most important takeaway, is the 130 trillion that the Glasgow Financial Alliance for Net Zero is the number on the private finance that is being mobilized. That sum and the financial institutions who have pledged to net zero by 2050, this is private finance. The announcement yesterday on Finance Day, day before yesterday, was that they will be subject to climate action plans. So those private financial institutions, mostly universal owners, banks as well.
Breaking up again, Wendy. I'm afraid the Scottish wind is very powerful. I think we lost Wendy. Diane, any comments?
I think one area that's probably not brought into this discussion is the focus on climate law, but without looking at its new intersections with human rights law. As we know from earlier in October, the UN Human Rights Council recognized the right to a healthy, safe, and clean environment to the extent that it did so for the first time, recognizing
pledged to net zero by 2050 with lots of disclaimers on interim targets, about 45% by 20. Okay.
I'm sorry. Diane, maybe finish what you were saying.
Yes, we're having technical difficulties. But one thing that's not explored here is that the constant reference is to Article 24 of the Paris Agreement and Article 14 of the Framework Convention on Climate Change, which very narrowly looks at disputes arising from these treaties. So to the extent that Article 14.1 in the Framework Convention refers to resorting to negotiations or other peaceful means of dispute settlement, I agree with Wendy, there's an opt-in mechanism for litigation or for arbitration. And there's a mandatory conciliation process. But to the extent that these are constrained by looking at climate change laws purely from the lens of these two treaties, then it would look like the dispute settlement mechanisms are fairly narrow. But this is precisely why the commission that was set up by Antigua and by Tuvalu set up the precise mechanism to try and explore looking at other treaties, such as the UN Convention on the Law of the Sea, which has provisions under Article 194 and other provisions of the convention in relation to the protection of the marine environment, which can trigger corresponding jurisdictional bases for dispute settlement, such as, say, an Annex 7 arbitration before the Permanent Court of Arbitration under the United Nations Convention on the Law of the Sea. There's also the option to get an advisory opinion at the International Tribunal on the Law of the Sea. It may also be of interest to everybody who's listening that, at least in the business and human rights space, the notion of protecting the right to a healthy environment as part of business and human rights disputes has started gaining traction, especially as a possible alternative to the ongoing national court litigation against, say, the fossil fuel producers. So the landmark decision this year in Milieu Defensive versus Royal Dutch Shell at the Hague District Court has given particular impetus and interest on the part of the private sector to explore business and human rights rules as a possible alternative to disputes that are falling right now in a parallel track in national courts. So we've seen what happened in Nevsun versus Araya at the Canadian Supreme Court, which expanded the duties of care in regard to corporations and their responsibilities, not just to respect human rights, but also potentially to protect human rights. Milieu Defensive is also just the latest in a string of landmark decisions that can also impact the calculus of the private sector as to their possible willingness to submit to a business and human rights arbitration quite similar to the Bangladesh Accords arbitration. So there's that necessary interface, especially important now that the United Nations has recognized, the Human Rights Council has recognized the deep intersection between climate change law and human rights. And when you bring that intersection into play, other dispute settlement procedures can necessarily also be triggered following the jurisdictional clauses in different treaties.
Very interesting. Wendy, I think, has had to leave us. So I'll turn again to Stephen to see if he has any comments as a follow-up to this.
Certainly, thank you, Olivier. And let me preemptively apologize that I too will have to leave in about 10 minutes. But I think that the business and human rights matter is absolutely critical here. And another entry point for this, if you like, in addition to the very important points that Diane has made, is in respect of commercial arbitration, when you're dealing with not just carbon credits, but also the far bigger contracts for renewables and other infrastructure. And you have incorporated by way of contractual terms, human rights obligations, grievance processes, affected communities processes, but also environmental integrity, and so forth, all according to the requirements of generally the funding institution, but typically with some scope for negotiation, especially if it's a sovereign on the other side of the deal. So then this, of course, raises a question for the arbitrators, because generally this is under arbitration, and for counsel, that you're dealing with a commercial contract that the disputed terms often turn on questions of international environmental law or international human rights law, or indeed emerging norms, which we are not all comfortable referring to as public international law, but are nevertheless becoming more and more prominent. So this is a capacity building challenge for arbitration community. And I think that centers have a very important role to play here with their constituents in terms of being a knowledge repository and perhaps a training provider for commercial arbitrators who are necessarily working on matters that go far beyond what we generally consider to be bread and butter commercial law. I'm happy to expand on that, but happy also to hear from others. Thank you.
If I may add to what Stephen has already pointed out, also perhaps in the interest of time, we are already seeing in the investment arbitration space the particular costs of regulatory changes that states are now trying to implement consistently with their commitments under Paris and under the Framework Convention. So to the extent that we're seeing so many of these cases, we've seen the solar cases, we've seen quite a number of cases involving the confrontation between environmental regulations and changes necessitated by environmental commitments. There's a two-track development and investment arbitration that we're looking at right now. One is the interpretation of that much derided, or to a certain extent, much popularized policy space, but also the existence in modern or later generations of investment treaties that provide consistency with environmental agreements that themselves have an evolutive provision that allows for the ratcheting up of a state's ongoing commitments in regard to environmental protection. And that's not coming into an easy path where it's investors that ordinarily initiate claims, when we see that host states at least have in theory, although not yet fully tested in practice, the ability to file counterclaims. It will be interesting to see, especially as states we anticipate will be radically transforming regulations down the pike in order to comply with commitments, in order to get to net zero neutrality faster than anticipated, how the private sector and how entities who are involved, particularly in foreign investment transactions across the globe, and how arbitral tribunals themselves will react and interpret investment treaties and the duties of states in particular to protect the expectations of investors within the changing climate of law and regulation that is being brought to bear on climate change commitments. Now, we haven't seen a case yet in investment arbitration that squarely litigates this precise confrontational issue, but we may very well see it the moment that we see regulations that impede, particularly on fossil fuel emissions. And we've seen already, at least from the Philippines, there was a couple of years ago, the famous carbon majors decision, where the Commission on Human Rights declared 41 carbon majors or fossil fuel producers as in breach of human rights law, as well as public policy within the jurisdiction for continuing to produce and to act in ways that are contrary to the Philippines' own environmental code. How that will play out and whether that plays out, say, in an investment arbitration setting, a commercial arbitration setting, or even potentially an interstate arbitration, will be something that's quite inevitable over the coming years.
Very good, Stephen. Thank you. This was a very important point on investor-state arbitration. Stephen, I know you need to leave us very soon, so I just want to invite you to make some last comments. The last question, that I wanted to turn to after that was basically the day-to-day business of arbitrations, and because we've got all these big discussions, public international law, etc. But how can we, as an arbitration community, help save the world, so to speak? Or what's our role in all of this, basically? What is the role of Arbitration Center in the face of the change of investor-state arbitration, with all of this commercial arbitration too, as we've discussed? What's the role of the arbitration community?
Well, I mean, there are many things, but let me just mention one. Of course, one of the reasons arbitration, and here I'm again referring mostly to commercial arbitration, why arbitration is preferred over different mechanisms is flexibility and the ability to adapt to bespoke requirements of certain disputes, certain industries, etc. So currently we see climate change presenting challenges to legal systems around the world and to courts, certainly to courts. We've seen a number of very progressive and impressive judgments, but we've also seen that courts do not have the freedom that arbitral centers do. So I've already mentioned the kind of capacity building, information sharing that arbitral centers can provide to their members, but also in the realm of looking at the rules and perhaps looking for the need for specific rules dealing with certain kinds of climate change disputes. An additional thing that arbitral centers can do, of course, is provide their services to particular institutions, particular markets, which are set up to deal with climate change. And that's been the case, for example, in terms of emissions trading, with the development of a bespoke gold standard foundation arbitral set of arrangements with, I think that was the PCA, but don't quote me on that. So there are many things, not having notes in front of me, there are many things that arbitral institutions can do, but one of the most important things is to put this on the agenda. Those of us who focus on climate and clean energy are a minority. Most colleagues are general commercial lawyers or are specialist arbitrators, but not specializing in climate change. So an institutional focus on this is very helpful, and that's why events like today are so wonderful. And a final thought, if I may, and this isn't my idea, I've stolen it from Wendy, but she's not with us. She mentioned that BVI, of course, is unique in that it is an international arbitration center, but it is also on the front line of climate change physically and in terms of its community, the community that surrounds it. So there must be a specific role there to bring those realities together and help to solve this problem. Let me close by saying thank you very much, colleagues. I regret that I'm going to miss the intervention of Francois, but I understand that this session is being recorded. So I do plan to catch up on it later on. Thank you, Olivier. Thank you, Diane, and Wendy, of course, and all the best for the ongoing discussion. Thank you.
Thank you, Stephen, and good luck with the negotiations for the rest of the conference. Have a good evening. Bye-bye. And so we will take this opportunity to ask Francois to rejoin us since we talked about BVI International Arbitration Center. So Francois, if you're around, please join us. I know Diane needs to leave also in 5 minutes. So maybe we'll start with you, Diane, and see if you have any comments on the question and also on the remarks of Stephen at the end.
I think one thing that I will suggest is that arbitration centers have a very crucial role in helping all stakeholders in climate change prepare for managing disputes arising from the transformations you will see in climate change. And that has to happen at all levels and all scales and all stakeholders. There are issues, for example, involving climate change refugees. There was a famous application by Kiribati refugees before the Human Rights Committee, but in reality, the Human Rights Committee was not able to do much insofar as those refugees are concerned. Those are matters that could very well fall within a business and human rights arbitration precisely because of the flexibility afforded by arbitration, especially on the reparative front, on the kind of reparations that arbitral tribunals can design, given the nature of applicable law. The second thing as well is for arbitral institutions to jump ahead of the curve and already start educating users of this particular form of dispute settlement. I often find it interesting when people talk about peaceful means of dispute settlement, they forget to talk about arbitration as one of those peaceful means. They tend to associate just negotiation and conciliation. And yet we know from the Charter of the United Nations that the peaceful means of dispute settlement include one of its oldest forms of dispute settlement, arbitration, which is by definition advantageous to parties that are in different jurisdictions that may need some ownership of the procedure for purposes of ensuring the legitimacy of a process. For those, for example, who mistrust the validity of the home court advantage in national court proceedings, there may be greater comfort in designing a particular procedure with input on both parties. So you could see that insofar as the flexibility of arbitration is concerned, there may very well be greater trust in a procedure. And we saw that play out in particular in the Bangladesh Accords, where the largest garments manufacturers joined with the International Labor Organization, with the state of Bangladesh, as well as with the unions representing garment workers in Bangladesh in a multi-party arbitration procedure. That only happens in arbitration because there is this necessary flexibility. And perhaps the last thing I'll close on is why in particular BVI is very central to this discussion. And I'll bring this back to my initial remarks regarding the alliance of small island developing states. It is very difficult on the part of large arbitration centers that are situated in the mainland to have any direct consciousness of the nature of loss and damage and how immediate that is in particular for small island developing states. It's not for nothing that every time the SIDS, the Small Island Developing States heads of state, go to New York every year to make an appeal to all leaders at the United Nations, the appeals have gone unheard. Because to a large extent, when we are in a different geography, largely insulated from the immediacies of climate change, it's hard to visualize why this is literally a matter of life and death for the Marshall Islands, for Tuvalu, for Kiribati, for 43 states in the world, who together just account for less than 1% of emissions, but altogether experience the loss and damage of rising sea levels, of flooding and inundation, of the loss of their population, of the growing refugee situation that these countries face. I support this particular activity at the BVI Arbitration Center precisely because the BVI Arbitration Center is uniquely positioned to make this message clear to everybody, that especially in regard to the interstate disputes involving the exact clamor of 43 states for particular redress insofar as the climate financing, which has dragged its feet for well over 6 years now, and in particular for the loss and damage and mitigation issues that are necessary for performance of these obligations under the Paris Agreement. I think the BVI is an excellent forum to spotlight these issues as they vividly occur, especially since the BVI has also experienced its own share of climate change impacts. So let me close on this front and thank Francois and thank Olivier, Wendy, and Stephen, and all those who have attended this webinar. And I look forward to further discussions on this subject.
Thank you very much, Diane, for participating. And we wish you a very nice end of your day. Thanks. That's great. So we'll maybe take a few minutes now, Francois, to understand, to follow on basically what Diane was saying on the role that the BVI International Arbitration Center could have in all of this, in all these future disputes. One thing that what made me think, when Diane was speaking last was, it feels like there is really like a crucial need for, I would imagine, even more so, for a diverse pool of arbitrators, basically, than the traditional, established pool of arbitrators in order to to understand, basically, you know, from different perspectives, the disputes that affect, for example, these small island nations. So can you tell us, I know that the center, you know, assigned the campaign for greener arbitrations, also the campaign for greener arbitrations Green Pledge. And so I'd like to understand, you know, what motivated you to sign this pledge, what role you foresee in all of these future disputes for your center, how you're uniquely positioned to address those, what are the measures you're taking, you know, to also reduce the carbon footprint of day-to-day arbitrations, you know, in your rules and in your practices, you know, at the center. So it's a little bit of everything. I apologize, but it's the airtime now is for you.
All right. So, well, I'll start by thanking Wendy, Stephen, and Diane in particular for making time in what you could all see was the really busy schedule to speak on this panel. I am a profound admirer of the work that Diane has been doing for the small islands and that fight she's been bringing up over and over again. I'm a big fan of Wendy and Stephen, and for all the work they're doing, you know, at COP26, but that they've been doing for the last 20 years, and it's a fight worth fighting for. And you know, I don't want to paraphrase what they've been saying, but to answer your 20 questions, Olivier, I will not take them in turn. Yes, we did sign the Green Pledge as soon as we could sign the Green Pledge. We also signed the Racial Equality in Arbitration Pledge. We also signed the Arbitration Pledge from Arbitral Women. Because going back to what Diane was saying, there is an interconnection between climate change and human rights and diversity and inclusion. And the BVI being, you know, a premier arbitral institution in the Caribbean, in a small island, the actual facilities of the BVI IAC are on reclaimed land of a sea. You know, we're now heading for 2.7%, but even if it was 2%, in 30 years' time, and I know it's easy to joke about this, but I don't want to have to join BVI Arbitration Week while scuba diving. And, you know, it is critical that the world realizes that when the Prime Minister of Barbados says it's code red and people will die and it needs to change, it's real. And as Diane said, we are uniquely placed as an institution to understand that message. The BVI was destroyed in 2017 by Hurricane Irma. So we've experienced the devastation. We understand climate change at our core, and we want to get involved. And, you know, if you're in London or New York or Paris, and you know it's the right thing to do. If you live in the BVI and you were here for Irma, not only do you know it's the right thing to do, you just have to do it. And you know, signing as a pledge is one thing, but we're trying to do other things. We're trying to get involved with all those initiatives that try to drive the agenda in the right direction, whether it's climate change or human rights. You know, at 11, we've got a live session where the BVI IAC will sign a collaboration agreement with CIARB, Global CIARB. And this is really a matter of formalizing the work that we have been doing for the last 5 years with CIARB, the BVI chapter, the Caribbean chapter, in trying to help train people in the Caribbean, in the BVI, about arbitration, about methods of dispute resolution that we hope will help improve the diversity of the panels of arbitrators, not only for the BVI IAC, but for panels all across the world. So we've been active, and Diane mentioned that, in the training of people inside the Caribbean. And we're very serious about this. I mean, it's part of our mission, ultimately, as an institution. But we also have been proactive in supporting initiatives like remote hearings and so on. The center was created knowing that we were in a hurricane corridor, and most of the tools that we've been using are cloud-based. We can all take our laptops and go and work somewhere else if we ever face a challenge at the institution itself. The new rules that we are publishing mid-month contain very specific provisions for virtual hearings, for soft copies of documents, certified soft copies of documents, and so on and so forth. And while our previous rules enabled us to do this, we are also working to ensure that this becomes the default position. This conference is another example of
Also, just one follow-up question. Sorry to interrupt, but when you say the default position, you're saying that in your new rules, it will be. Are you saying that virtual hearings and no paper will be the default?
So the rules, no, the rules will say that we permit electronic certified copies of awards, for example. That the tribunal, I mean, an arbitral institution should not be prescriptive in how a tribunal and parties should handle the arbitration. However, the new rules will provide the ability for the tribunal to direct remote and virtual hearings, for example, or will empower the tribunal and to ensure that a notice, for example, can be transmitted electronically or by any means of communication that provides or allows for a record of its transmission. And this was implied before. It will now be specific. I also think, when it comes to conferences, the hybrid will become the norm. And we've held in-person conferences in BVI in the past, and I think going forward, despite the few technical difficulties we had for this panel this morning, hybrid will become the norm. I think the value people get from hybrid conferences, from the recording of these sessions, will continue in what I tend to call the new normal.
Excellent. So in terms of disputes, like climate change related disputes, just to finish on that, are there any specific measures that you're planning to implement? Like, are you looking into, for example, getting actively involved in these new mechanisms, to potentially arbitrate disputes, in the context of these emissions trading mechanisms and so forth, all these other, provisions, these new disputes, basically that will inevitably arise, from these mechanisms that are being created.
So we, as an institution, we believe we are intrinsically relevant to these conversations, and so we are participating to these conversations, and we're hopeful that people will recognize that there is a certain degree of legitimacy for an arbitral institution like the BVI IAC to be involved in the resolution of disputes related to these specific topics. This is not something that, as an institution, that you can force. But as I said earlier, We are keen to get involved. We believe we are relevant to be involved, and we must certainly have the skills and technology to be involved. So this is a continuing conversation, and we're hopeful that we will continue to be part of the landscape of the large number of people and institutions that are trying to make an impact and drive the agenda in the right direction.
Great. Thank you. I'll just finish, because I'm the chair of the Campaign for Greener Arbitration's North America Committee, so I'm keen on asking you certain specific questions in relation to that. Are you doing anything to promote basically the Campaign for Greener Arbitration's protocols? I'm thinking notably about the model green procedural order that is contained in the protocols, and which we hope will be increasingly discussed, at the onset of an arbitration between the tribunal and the parties, basically to try to adopt, regardless really of the arbitration rules, to adopt some measures to make that specific arbitration greener. Communicating electronically, of course, but not printing paper, etc. So are you doing any kind of training about that? And tangentially, I guess, maybe training of your panel of arbitrators, regarding new technologies and how different tools can be used in order to increase the familiarity of your arbitrators, basically of your arbitration panel, with these tools, making them more comfortable, not to have to request paper, not to have to meet, hold in-person hearings, etc.
So in terms of what we're doing in practice, I mean, outside of the things that we do at the facilities themselves, we do not right now have a plan to have a blanket training for all the arbitrators, but this is part of the conversations that we have with the arbitrators for the cases that we administer. And so we obviously propose a long list of services, inclusive of our ability to do everything remotely, e-bundles, electronic document production, and presentation. We tell them that we can manage the case management conferences remotely, the hearings remotely. We show them examples of what they can expect if they so choose to use those services, because there are videos online of work that we have done that was not confidential, but that shows proof that it works. And I think one of the barriers to acceptance when it comes to increased use of technology for arbitral proceedings is fear of change and the lack of access to a visual representation of what it is. And I think a lot of arbitrators and a lot of people in general are not adopting the new technologies or the new way of doing things because they've never done it before, and because they're not sure it's going to work, and so on and so forth. But when we show them what a hearing will look like if it's entirely remote, when we show them, or we put them in touch with a court reporter that can do live transcripts remotely, and they have those conversations, then the more people we bring into that knowledge, into that state, the bigger the army becomes of people that can sell that message to others. And I think this in turn will have a trickle effect. Those kind of changes don't happen overnight, but I think the more we talk about it, the more we explain, the more we train, the sooner we'll get to the other side.
Absolutely. So I guess I don't know if the audience has the ability to ask a few questions which would be addressed to you, Francois, at this point, since all our other speakers have left us and have returned to the conference in Glasgow. Do we have any questions? Do we know? Does the audience have the ability to ask questions? I don't know.
There's a question? No questions. So we can close.
All right. Okay. Well, it was a pleasure to be here with you this morning. Again, I wish I was with you in person. I saw that you had some nice receptions. I hope that this went very well and that you had a great time to celebrate Arbitration Week in the BVI. This is fantastic. And I wish you a great end of the program.
Thank you very much, Olivier. Thank you for moderating. Thank you to all the speakers. And we'll be back online in about 50 minutes for the sharp signing ceremony. Thank you, everyone.
Thank you. Bye-bye.